Question to the Minister of Labour. Does she stand by the statement made on her behalf on 22nd September 2010 in relation to the Employment Relations Amendment Bill No. 2, quote, the government made sure there were adequate protections in the bill in a number of areas in terms of the trial period?
The Honourable
Mr.
Kate
Speaker,
Wilkinson.
Yes.
Darien Fenton.
The Minister. Is the requirement for the 90-day trial period to be voluntary, as she claims, one of the so-called protections that she's referring to? And if so, will she rule out making the 90-day trial period a default provision for all employers?
The Honourable Kate Wilkinson.
Yes and no.
Darien Fenton.
Oh, thank you, Mr. Speaker. To the Minister. What are the requirements for good faith negotiations in relation to reaching agreement for a 90-day trial period? And what protections are there in the bill for a prospective employee if genuine good faith negotiations don't occur?
The Honourable Kate Wilkinson.
Mr. Speaker, there are several protections that are in the legislation, and I refer the member to Section 4A of the Act, Section 134 of the Act, Section 103, Subclause 1, B, D, C, E, F and G.
Darien Fenton.
Gee, goodness, it's good to know the Minister can count. To the Minister.
Order. I want to hear the question. Darien Fenton.
What protections or remedies are available to an employee
I apologise to the member. Look, members, the noise level is just unreasonable. I want to hear this possibly last supplementary question today in today's question time. Darien Fenton.
Thank you, Mr. Speaker. To the Minister. What protections or remedies are available to an employee who is dismissed under the 90-day scheme and given no reason, given that Section 113 of the Employment Relations Act says, quote, if an employee who has been dismissed wishes to challenge that dismissal or any aspect of it for any reason in any court, that challenge may be brought only in the authority under this part as a personal grievance, end quote. Yet Section 67B says that a person dismissed under the 90-day scheme may not bring a personal grievance or legal proceedings in respect of the dismissal.
The Honourable Kate Wilkinson.
Speaker, there are many other grounds upon which a personal grievance may be pursued, and the member, as I explained, can find them in the Employment Relations Act, Section 103, 1B through to G, as well as breach of good faith conditions in Section 4A or breach of employment agreement conditions in Section 134. And if the member would like a line-by-line advice and lecture on how to read a statute, we are happy to oblige.
I think that brings to a close questions for oral answer. I call on Government Order of the Day number 1.